With your permission, sir, shall we start?
Yeah, sure.
Thank you, sir. Uh, so a very warm good morning to all of you. On behalf of the organizers, Department of Biotechnology, Maharishi Markandeeshwar University, Mulana, and the Integrated Association of Medical Basic and Social Sciences, IMBSS, I warmly welcome you to this today's webinar. And for this webinar, we have a very eminent personality with us. This is Miss Neha Goyal. So it's my pleasure to introduce the speaker of the day. Ms. Neha Goyal is an IPR practitioner who is having a total working experience of more than 15 years in intellectual property rights. She is a private student of Punjab University. She did a master's in bioinformatics with a gold medal and served 3 years as a lecturer in a couple of reputed colleges. Thereafter, she moved to a couple of international IPR firms and she has extensively hands-on experience in handling patent analytics, patent drafting, patent filing, patent prosecution, trademark, and design-related portfolios. She has also worked for a prestigious client like Microsoft, Boston Scientific, Unilever, GSK, Top Glove, KW University,
After some time, it's seminar.
and many more. So she has also worked with the many engineering colleges, to name a few: the ABS Engineering College, Baba Farid College of Engineering, Indraprastha Engineering College, Krishna Engineering College, Panveer Engineering College, and many more. So she has also worked with many startups, and besides this, she understands the IPR laws not only for India but many countries around the globe like Europe, UK, US, Australia, Germany, and Canada. And currently, she is the founder of Untitled Consultant LLP and heading a team of around 10 technical and legal professionals. So we warmly welcome you, ma'am, for this today's webinar. So for the further proceedings and for the opening remarks, I would like to request Dr. Anil K. Sharma, who is a professor and head Department of Biotechnology, Maharishi Markandeeshwar University. Sir, with your opening remarks, over to you, sir.
Thank you, Dr. Ujjwal. Thanks a lot. So, a very good morning to each and everyone. First of all, it's a proud privilege for me to profoundly welcome Ms. Neha Goyal, who is the Director, Unipatrade, a very unique name. I would like to ask such a enticing name for her company. So, and I profoundly welcome you, ma'am, with immense joy and pride. And the topic which she is going to speak upon is the patent requirements in India, which is, I think, holds importance in current scenario. As far as we see a surge of patents from India, and India has been placed in, I think, top 10 countries. I think India was at 7th position in terms of patents granted. More than 28,000 patents were granted during the year 2021 itself. So, and making its place in the top 7. And in the global innovation index also, India has improved a lot with the position at 46 now, while it was at 81 during the year 2016. So all this happened because of the innovations, startups which have come recently, and our government also have made tremendous efforts to bring down the filing fee, as well as making it more comfortable for the innovators. Because the strength of a patent doesn't come from the claims, actually it comes from the invention. So actually some concrete steps have been taken during the past 4 years, and by virtue of which you will be surprised that more than 14 lakhs trademark registrations have been done in India during the last 4 years. which is remarkable. And I think if we go with the same pace, uh, we know days are not that far off when we will surpass China, who is leading the table on the top of the global this patent grants, and followed by US. So with that said, I think the today's talk is going to be very interesting one, especially for the students, especially for the faculty members, innovators, and I truly anticipate that we all will thoroughly enjoy the talk and would take concrete measures to contribute to the nation's startup programs, as well as to their growth of their self, as well as protecting their property, innovation property. So with that said, I again profoundly welcome, ma'am. Thank you, and profoundly welcome you with joy, immense joy and pride. Over to Dr. Ujjwal for further proceedings. Thank you, ma'am. Thank you.
Thank you.
Thank you so much, sir, for your remarkable words, and always your words are encouraging, not only for the faculty but also the students also. Now, without coming in between the presenter and the participants, now I would like to request Ms. Neha Goyal to start her presentation. Over to you, ma'am.
Thank you, sir. I'm just sharing my screen. Sir, please confirm, are you able to view the screen?
Yes, ma'am.
Okay. Thank you so much. Good morning to all of you. Very rightly, just Dr. Anil Sharma sir mentioned that, it's very encouraging to, I really liked his point that he said that, very soon we would be, that day will come then when India will become number one in patent filing as compared to that of China. But sir, here and for all the participants, I would just like to add one more point that it's okay that, we file patent applications as many as possible, and everybody is now trying, especially when after our Prime Minister, Mr. Narendra Modi, he introduced Make in India concept and startup policy. Now everybody is getting aware of what is patent, what is intellectual property right. But for us, it's very, very important to understand that patent filing just won't make any difference. But yes, we have to become owner of that property. We have to get grant of the patent right. So that is very, very important. India is always known for जुगाड़. एक जुगाड़ एक ऐसा कीवर्ड है, you cannot just find out anywhere in the dictionary. I would be using both the languages, English and Hindi, for your comfort. So it's not like that Indians, they just don't know how to invent, or they don't have any discoveries, or they are not that much intelligent that they have to be dependent on China, on countries like China. Jugaad is always there in their DNA. Even if we check our, manuscripts of old traditions, we just check and we will come to know that medicine, Ayurveda, apart from Ayurveda, even the surgeries, they were being discovered here in India only. So our ancient saints, they gave us so many technologies, they gave us so many inventions that even we ourselves are not aware of, but the foreign countries are aware of. And these kind of messages you often get on your WhatsApp and these days. But we just don't know how to protect it. Like we say कि घर तो मिल गया है, पर घर का ताला हम नहीं लगा सकते. वो हमें लगाना ही नहीं आता. क्योंकि India always believe in giving. But now it's very, very important to put lock on our property. Just like you own a house, you purchase a flat, or you purchase a shop or any vehicle, you always go to the court and you register it. Why you register it? You register it on your name. so that anybody else cannot claim that property. So that is your physical property. That physical property, even in will, wasiyat mein, like your parents or grandparents, they give it on your name. So similarly, intellectual, whatever is there in our mind, that also we can protect. That also we can assign it to our next generation in the will. आप वसीयत में भी अपनी आईपी जो प्रॉपर्टी है, these are your assets. आप intellectual property assets को भी you can transfer it to that will. Now, often there are confusions that, patent, trademark, copyright, design, what are all these? So I will not go to each and every detail of all the different types of IP, but yes, I'll just quickly, recapitulate the concept that what is the difference between the different types of IPR. So intellectual property rights means that you have a legal right on your intellectual property, and these are the different types of intellectual property rights. Now the question arises for every common man, every common citizen of India, that what do you mean by different types of IPR? I mean, where we should go for what kind of product? Mobile phone, everybody has mobile phone in their hand. Now, suppose you are manufacturer of this phone. You are inventor. You have come up with some invention on this phone and you have come up with a new product, that is this phone. You can protect this product from all the aspects of IPR: patent, trademark, design, and copyright. Now, if it would be really great, if any of the participant can just help us to understand, if they know that how this can be covered in all the aspects. Anybody from the participants? No one? Okay. Suppose you have come up with a new kind of a software or an app on this mobile phone, then you will go for the patent, that is utility. Or if you have come up with some new method of making this phone, इंडस्ट्री में फोन की बॉडी भी तो बनती होगी, उसके लिए सपोज कोई प्रोसेस एक नया you have come up and you have come up with different steps that this, with the help of this method, my manufacturing cost has reduced, my manufacturing raw materials, they have reduced, so then you will go for patent, which is known as utility patent. Then comes a trademark. Now if you have come up with this new product in the market, you will give some name to this market, to this product. So that will be protected under trademark. And aesthetic view, that how your phone is looking like. Is it a keypad? Is it an oval shape? Is it a square shape? So that aesthetic view, that can be protected under design. And then comes a copyright, which is like the booklet which you often get along with the phone in the box. So that is often there is written copyright. Even in my slides, you will see at the end, I have written copyright. So copyright means whatever the content is written or in the user manual, which you get along with the phone, that is copyright. So I hope you have got clarity, the different types of IPR. So this is how I just thought I should cover these points quickly. So now let's come to the main topic of the presentation, patent. Now you have understood that if you have anything in your mind, it can be product or it can be process. आप एक प्रोडक्ट पूरी की पूरी प्रोडक्ट को भी आप प्रोटेक्ट कर सकते हैं, या फिर एक मेथड ऑफ वर्किंग ऑफ दैट प्रोडक्ट या मेथड ऑफ मेकिंग दैट ऑब्जेक्ट, और इन इफ आई वुड से अगर आप केमिस्ट्री या फार्मास्यूटिकल डोमेन में जाते हैं या बायोलॉजिकल डोमेन में, लाइफ साइंसेस में जाते हैं, सो देन you can protect, for example, a medicine, a tablet, or you can protect a method of making that tablet. Even for the machine, if you go to mechanical or electronics, so there also similarly, you can protect a product itself or a method for making that product if there is something different. Now patent, when you get some intellectual, some idea in your mind, you will go for protection of the patent rights. For that, you have to go to the patent office. In India, there are 4 patent offices. Now, for this particular idea, you get protection only in India, not in US or in any other country. So that's why we say patent are territorial rights. अगर सपोज आपने इंडिया में एक अपना कोई भी आइडिया उसको इन द फॉर्म ऑफ पेटेंट या एनी इंटेलेक्चुअल प्रॉपर्टी आपने प्रोटेक्ट किया है एंड somebody else copies it and tries to commercialize it in US, you cannot stop that person. For that, you have to file your patent application in US. Because India के laws India तक के limited है, US के laws US की boundary तक limited है. So for that, we have to file in foreign countries if we want protection in the foreign countries. Limited period time of exclusivity, this is 20 years. Government of India हमको 20 साल का time देती है of exclusivity, which means that in 20 सालों के लिए आप अपनी product को sell कर सकते हैं, use कर सकते हैं, commercialize कर सकते हैं, you can do anything. And the most important right which we get for 20 years is you can also stop the third person who is trying to commercialize your product or use your product without your permission. अगर आपने सपोज अपना एक नया घर खरीदा है, अब आपने घर को किसी को रेंट पे नहीं दिया है और कोई जबरदस्ती आपके घर में आके रहने लग जाए, of course you will stop that person. Even for that you have to go to the court also. So similarly, अगर आपकी कोई प्रोडक्ट आपकी परमिशन के बिना उसको या तो किसी को लाइसेंस आउट करता है या फॉर अ पर्टिकुलर टाइम पीरियड उसको it allows the some person to use that product or it sells or further उसकी manufacturing करके he starts his own venture, you have right to stop that person. And this exclusivity period is 20 years, which is being given by the government of India. Now, whenever you go to a shop, आपने कोई product खरीदी, ऐसा तो है नहीं that you will not give money. So for anything, there is give and take. कभी भी आप शॉप पे बिना पैसे दिए आप चीज नहीं खरीद सकते हो. So similarly, अगर आपको गवर्नमेंट ये 20 साल का टाइम दे रही है, so for that government also demands something in return. What does it demand? It demands that you have to disclose all the details of your invention. आपकी वो प्रोडक्ट आपने कैसे बनाई है, each and every step, even if it is formulation, then the entire composition. So everything you have to disclose to the government so that any student, even any student or any technical person of that field is able to make that invention by following the patent application. So that we will discuss later on in more details. Now the next very, very crucial point is, which question often comes to us, कि मैम कोई भी invent कर सकता है. We already have jugaad, so many jugaad. The concern is here that we hardly pay attention to around what is happening. In one of our clients, एक professor है, so she really gave a very beautiful concept. उनका एक invention था, the Hindu idols, जैसे गणेश विसर्जन होता है, तो हमारे हिंदू रिलीजन में क्या होता है that there are so many idols. तो हम लोग पानी में उसको विसर्जित कर देते हैं या फिर हम किसी ना किसी ट्री के नीचे छोड़ देते हैं. अगर पानी में करते हैं तो इट पोल्यूट्स वाटर, एंड अगर हम ट्रीज या कहीं पे भी ऐसी रोड पे फेंक देते हैं, रख देते हैं, तो इट्स एन इंसल्ट टू दोज आइडल्स. तो अब देखिए, अब इस तरीके की प्रॉब्लम जो हमारी खुद की है प्रॉब्लम, उसके लिए हम चाइना के पास तो नहीं जा सकते कि वो हमें सॉल्यूशन दे, या यूएस के पास नहीं जा सकते. इसका सॉल्यूशन हम ही ढूंढ सकते हैं. और इस तरीके की प्रॉब्लम सिर्फ इंडिया में ही हो सकती है और कहीं नहीं हो सकती. So she really came up with a very beautiful solution, and we have filed the patent application for that. So why I'm trying to give this example is that we have to make our mind conscious of our surroundings. अब मेक इन इंडिया के बाद now we have started developing, we have started finding out the problems. ऐसा नहीं है कि you have to come up with some absolute solution. Problems पहले से ही होती हैं, उसके लिए solutions भी हो सकते हैं, but then again those solutions will have certain problems. So उन problem को आप further कैसे solve करोगे या with your advance or with your advantages, then of course you can invent it. Now there is no bar of age. ऐसा नहीं है कि okay जब मुझे job मिल जाएगी Google में then only I will find out some solution. It's not like that. You can find a solution to any problem at any age. You would be surprised that one of our inventors, when he came up with this very simple solution, he was just at 5 years of age. अगर 5 years of age का बच्चा प्रॉब्लम ढूंढ सकता है, सोल्यूशन ढूंढ सकता है, so why not we adults? Irrespective of any status, it's not like that कि the only that university is people they can do, we cannot do. It's not like that. Irrespective of any qualification, you need not to have कि हमें PhD करना है, postdoc करना है, या हमें कुछ BTech, we will complete our degree, then only we will find out something. It's not like that. Anybody can invent it, irrespective of any designation. It's not like that when I will become scientist, then only I will find a solution. No. You can find a solution to any problem at any age, irrespective of your status, qualification, and designation. Now, अब आपने पेटेंट एप्लीकेशन फाइल करने जाते हो, often हमारे पास ये challenges आते हैं, especially with the academics. Companies are still they are aware of their rights and everything. So उनकी काफी हद तक inventions जो होती हैं they already know. बट हमें चैलेंजेस वहां पे आते हैं जहां पर स्टूडेंट्स या फैकल्टी या रिसर्चर्स इन्वॉल्व होते हैं. वहां पे हमें क्या चैलेंज आता है? ऑफन इन्वेंटर्स ऑफ एकेडमिक्स दे कम अप, दे से कि मैडम ये हमारा आइडिया है, आप इसको फाइल कर दीजिए, जब एग्जामिनेशन होगी हम तब देखेंगे. इट्स नॉट लाइक दैट. आपने एक बार अपनी पेटेंट एप्लीकेशन सबमिट कर दी पेटेंट ऑफिस में, यू कैन नॉट मॉडिफाई इट लेटर ऑन. आप उसका स्कोप नहीं बढ़ा सकते हो. अगर सपोज मैंने एक ब्रश डिस्कवर किया है एंड दैट ब्रश क्लीन्स कीपैड ऑफ माय लैपटॉप, ओके, और मैंने अगर अपनी एप्लीकेशन में यही लिखा ना कि वो लैपटॉप को क्लीन करता है, तो वो लैपटॉप को ही क्लीन करेगा. अगर मैं बाद में ये बोलूं कि ये तो किसी भी विंडो पेन्स को कर सकता है, किसी भी इरेगुलर सरफेस को भी कर सकता है, नाउ आई कैन नॉट ऐड ऑल दिस थिंग्स, तो मुझे वहीं तक ही मिलेगा. So it's very very important कि ग्रांट के लिए आपको जो भी डिटेल्स देने हैं वो आपको पेटेंट एप्लीकेशन फाइल करने से पहले अपने एजेंट को पहले ही देने होंगे, और वो उस टाइम पे ही हो सकता है. Yes, you can amend it, but you cannot cross the limits. उसके लिए भी there are some ifs and buts, some rules and regulations are there. Now for grant criteria, जैसे आप अपनी पीएचडी के लिए या कोई रिसर्च के लिए या आप अपना बीटेक के प्रोजेक्ट के लिए यू फाइंड आउट सम रिसर्च टॉपिक और आप उसके लिए देर यू गो फॉर पब्लिकेशन इन सम रिसर्च पेपर जर्नल, तो वहां पर उसकी ऑथेंटिसिटी चेक होती है कि क्या वो पब्लिश होने के लायक है या नहीं है. तो सिमिलरली जब आप अपनी इन्वेंशन के लिए एप्लीकेशन पेटेंट ऑफिस में भेजते हो, तो पेटेंट ऑफिस दे एग्जामिन योर एप्लीकेशन ऑन बेस various criteria, and there are main 3 criteria. Dr. Ujjwal just told me that university have filed many patent applications already, so I'm damn sure कि आप में से काफी inventors they already know what is FER, examination report, जो कि पेटेंट ऑफिस से इशू होती है. तो आपकी जो पेटेंट एप्लीकेशन है टेक्निकल एग्जामिनेशन होती है. फॉर दैट देयर आर 3 स्टेप्स. द फर्स्ट वन इज नॉवेल्टी. नाउ नॉवेल्टी मींस न्यू, समथिंग न्यू। क्या आपका जो आइडिया है, अब आपने तो बहुत सारे आइडियाज सोच लिए, वी थिंक अराउंड 60,000 थॉट्स इन अ डे, और 60,000 थॉट में से बहुत सारे आइडियाज भी आते हैं। Mothers या housewives or women, you know, they work in kitchen, so many ideas come up कि इसका ये जुगाड़ कर लेते, इसका ये कर लेते, इसका वो कर लेते हैं। तो इसका मतलब हम किसी भी आइडिया को पेटेंट फाइल कर सकते हैं। You can, but there are some conditions, and one of the condition is that your idea, it has to be novel, it has to be new. It can be absolutely new. Absolutely new means कि कहीं पहले कहीं पे भी नहीं था, or it can be new also. New means there can be some improvements in already existing idea. अब आप नोवेल्टी आइडेंटिफिकेशन के लिए आप सेल्फ चेक कैसे कर सकते हो? देखिए, आप जब भी एजेंट के पास जाते हो या फिर अपने आईपीआर सेल में अपना सबमिट करते हो आइडिया, उससे पहले यू शुड डू सम होमवर्क सो दैट इट सेव्स योर टाइम, योर मनी, योर एफर्ट एंड the other person's effort, money and time also. For that, जैसे आप अपने रिसर्च टॉपिक को यू डिवाइड इट इन द फॉर्म ऑफ की फीचर्स, दैट ए बी सी, मेरी ये प्रोडक्ट के ये 3 फीचर्स हैं जिन पे मैंने काम किया है, एंड देन फॉर दोज की फीचर्स, लिस्ट ऑफ की फीचर्स, यू कैन गो टू गूगल डेटाबेस विच इज कंप्लीटली अ फ्री डेटाबेस, गूगल पेटेंट्स, so in which there is a complete database of worldwide patents. So please note this point that for पेटेंट फाइलिंग आपके जो राइट्स हैं वो इंडिया टेरिटरी में लिमिटेड है, पर जो नॉवेल्टी जो चेक होगी आपकी इन्वेंशन की, दैट वुड बी वर्ल्ड वाइड, पूरी दुनिया में आपका चेक होगा, एंड फॉर दैट यू हैव टू गो थ्रू द गूगल पेटेंट्स इन विच यू विल गेट द पेटेंट रेफरेंसेस। अब क्या पेटेंट रेफरेंसेस होना ही काफी है? नो, you also have to check non-patent references, which means like your research papers, your publication papers, YouTube, Amazon, Flipkart, anywhere, books also. So आपका कहीं पे भी नहीं होना चाहिए. So this is how. Just अब एक सिंपल सी एग्जांपल लेते हैं। अभी कोरोना के टाइम में से मास्क की अभी हमारी इतनी अच्छी हैबिट हो चुकी है that everybody has mask at their home, in their purse, in their bag, कहीं ना कहीं तो हमें मास्क ढूंढ ढूंढ के मिल ही जाता है। अब मास्क के लिए बहुत सारी टेक्नोलॉजी डेवलप हुई, बहुत सारे मास्क आए, किसी ने हेलमेट वाला मास्क बनाया, किसी ने कोई टेक्नोलॉजी फिट कर दी, किसी ने स्पीकिंग के लिए टेक्नोलॉजी फिट कर दी। So many patents were filed for the mask. Now one of the problems that we identified, that the people who are specky, they often get a problem कि जब वो मास्क पहनते हैं, their glass, it gets fumes on the glass, on that lens, so it becomes very inconvenient कि वो हर बार उसको clean करें, और whenever they take a break तब then also. So now this is the problem. अब इसके लिए हमने suppose we came up with a solution. Now solution would won't be mask, पर उस टेक्नोलॉजी के ऊपर, उन पॉइंट्स के ऊपर आपने जिस टेक्नोलॉजी को इस मास्क के ऊपर इंप्लीमेंट किया है, so you will divide that technology into A, B, C key features, and then you will find it in Google Patent Database or a simple Scholar database. Now आपने Google Patents पे सर्च किया, आपने Google Scholar पे सर्च किया, and all the various public databases and resources. So there would be 2 pathways. जैसे आप अपना रिसर्च के लिए टॉपिक सिलेक्ट करते हैं, so वहां पे भी आपके लिए you have 2 ways. Either you will go with that research, you will identify, okay, इस एरिया में there is less research, it's a white area, so I can go ahead with the research. So you have no doubt you will go for the next step, that would be drafting and filing the patent application. Else you can brainstorm for the improvements. Means if you have already some prior arts, already some technologies are already there which are very much similar to your solution, then you can think कि उनके क्या disadvantages हैं, and then you can develop or improvise your solution accordingly. Now second criteria for the grant is inventive step. अब सपोज आप एक शॉप पे गए, शॉप पे आपने कोई प्रोडक्ट खरीदा, शॉपकीपर ने आपको उस प्रोडक्ट से मिलता जुलता आपको दो प्रोडक्ट्स दिखा दिए, एक का रेट ज्यादा है, एक का रेट कम है. ऑफ कोर्स यू विल आस्क दैट पर्सन कि भाई काम तो दोनों का सेम है, हाउ देयर रेट इज वेरिंग. He will say, this has this advantages and this has this is this. So based upon the features you decide. So controller is definitely going to ask you कि आप ये जो आइडिया लेके आए हो हमारे पास, ये solution, what are the benefits of this solution? How this invention is better over the existing prior art, जो पहले से ही आपके prior arts हैं, उनसे ये कैसे better है. So for that आपके दो रास्ते हो सकते हैं, या तो आप कॉस्ट कम करोगे या फिर उसको टेक्निकली आप इंप्रूवमेंट्स करोगे. अब कॉस्ट कम करने का मतलब ये नहीं है कि आपने जो मटेरियल उसमें यूज हुआ था उसकी जगह पे आपने एक चीप कॉस्ट का सोल्यूशन लगा दिया. फॉर एग्जाम्पल, मेरे पास पंखा है, अब पंखे के मैंने कोई घटिया मटेरियल के विंग्स लगा दिए एंड आई एम सेइंग कि मैंने कॉस्ट रिड्यूस कर दी. नो, this type of invention is not considered as inventive step. अगर आपने उसमें technically improvement कर दी उस पंखे में, that it has improvised the efficiency of the fan, so then you can definitely go for inventive step. So it means आपके ऊपर this objection can be overcome. But it should not be like कि मैंने दो चीजों को mix कर दिया कि okay, I was feeling very hot, तो मुझे एसी चलाना पड़ता था जब when I was working on my laptop, तो मैंने क्या किया, एक छोटा सा एसी या फिर मैंने एक पंखा लगा दिया अपने लैपटॉप के ऊपर. तो ऐसे वाले इन्वेंशंस भी कंसीडर नहीं होते हैं एज इन्वेंशंस. So I mean to say that your invention has to be better over the existing prior arts. There must be some technical advancement or economic advancement. Now inventive step को prove करने के लिए what extra you have to do? You have to submit all the experimental data in your application, all the benefits of your invention, what problems that your invention is solving, problems that your invention is going to overcome. So all these, points have to be there in the patent application. So being inventor, it's very, very important that you give all these details. जैसे हम डॉक्टर के पास जाते हैं ना, We always say कि डॉक्टर को जब तक अपनी सारी बीमारी के सब सिम्टम्स नहीं बताओगे, डॉक्टर आपका सही इलाज नहीं कर पाएगा. That's why वो आपकी सबसे पहले आजकल तो in the hospitals they do all the screening methods. So similarly, पेटेंट एजेंट के पास भी जब तक आप अपनी इन्वेंशन के सारे डिटेल्स डिस्क्लोज नहीं करोगे, he will not be able to help you in the grant. So it's very, very important that you disclose all the details. Now, apart from these 2 points, we also mention industrial applicability, one of the grant criteria, which is very, very important. और इस पे objection बहुत कम आता है. Industrial applicability means that your idea has not to be some superficial idea. कि मैंने एक इंजन बनाया, इंजन में मैंने इनपुट तो डाली नहीं पर आउटपुट हो रही है. It's not possible. So your invention should be such like that your invention is being able to get manufactured in an industry. So this is very important criteria. So ऐसा नहीं है कि कुछ भी आया माइंड में हमने फाइल कर दी. It's not like that. Now apart from these 3 steps, novelty, inventive step, and industrial applicability, there are some other essential requirements. I told you in the beginning that government asks you something in return of 20 years of exclusivity period. Government आपसे चाहती है कि आप complete details अपनी complete specification में दीजिए. Now complete specification means your patent application. So you have to give all the complete details. आपका सिस्टम वर्क कैसे कर रहा है, एंड कि अगर हम ड्राइंग से किसी को समझाने की कोशिश करते हैं, so that person, they understand very readily. So similarly, the controller, he is also going to understand your invention in very, a speedy manner. So it's always good to give drawings, as many as possible. You have to give abstract, title, so in which you have to give gist of your invention. So it's not like that कि आपने title इतना बड़ा दे दिया, आपने fancy titles दे दिए. No, it has to be very much simple. It should be related only to the application. It should not be that much broad. It should not be that much narrow. So we have to be extra cautious for the details in complete specification. For life sciences, yes, there are some additional essential requirements like NBA approval or biological materials details. So if you request, then I can share details at end of the lecture. Now the question arises, many of you will say कि मैम ने तो डिस्करेज कर दिया, भाई आइडिया भी आए माइंड में, पेटेंट भी फाइल करें, पर उसके लिए हमें कंप्लीट डिटेल्स देनी पड़ेगी. तो क्या हम सिर्फ आइडिया फाइल नहीं कर सकते? एंड दिस क्वेश्चन इज देयर फ्रॉम मेनी ऑफ द इन्वेंटर्स टू अस. यस, यू कैन फाइल आइडिया, बट नाउ द क्वेश्चन अराइजेस कि अगर आइडिया फाइल कर सकते हैं, सो देन अभी तो हमने टेस्टिंग नहीं की, अभी तो हमने डिटेल्स नहीं किए, सो देन हाउ वी कैन फाइल सिंपली आइडिया? एंड मोर ओवर वी ऑल्सो से कि जैसे ही आपके माइंड में आइडिया आता है, यू फाइल इट एट दैट टाइम ओनली, so that कि somebody else does not copy it. Because अगर आपने suppose देरी कर दी अपना आइडिया फाइल करने में, और आपके साथ में आपके फ्रेंड को आपके आइडिया के बारे में मालूम है, and that friend is going to the patent office and he files the idea, patent office is going to give preference to that friend unless we prove कि उसने गलत तरीके से हमारा आइडिया चुराया है. And do we need prototype for the grant? Now grant here I just want to again clarify, ये स्पेशली रिसर्चर्स academicians उनको कंफ्यूजन होता है कि ग्रांट यहाँ पर वो रिसर्च ग्रांट नहीं है कि गवर्नमेंट आपको पैसा देगी. ग्रांट का मतलब है गवर्नमेंट इज गिविंग यू द लीगल राइट्स ऑन योर प्रॉपर्टी. जैसे आपको अपने घर के मकान के ऊपर राइट्स आपको देती है ना सरकार, वैसे ही यू गेट the rights on your property. So this is the grant. That is not the grant कि आपको government पैसा देगी. Yes, we have a provision for filing only idea. That is provisional application. आप अपने idea को लेकर you can submit your application to the patent office and then government give you 12 months time to file the complete application. Now in this complete application, you have to give all the details of your application. So once you have submitted your invention details in the complete application, please mind it. So then you cannot modify or add later on beyond scope of the subject matter which is disclosed previously. Now this is the patent process which is being followed worldwide. We have already discussed that we identify novelty. I have already told you कि आप अपना homework करेंगे सबसे पहले. That is, you will search Google and Google patents. Then if you are satisfied, you will go to the patent agent or the IPR cell. They will examine novelty of your idea, of your invention. Then the patent agent is going to prepare draft of the patent application, जिसमें technically and legally आपका document is being prepared and various other formalities are being done, and then your application is being filed at the Indian Patent Office. Your application gets published here. अब यहाँ पर again I want to clarify a misnomer कि ये जो publication है, this publication is not like the publication of your research paper. यहां पर पब्लिकेशन होता है कि आपकी एप्लीकेशन पब्लिक में डाला जाता है, सो दैट इट इज लाइक टू टेल एवरीबडी दैट दिस पर्सन हैज फाइल्ड हिज एप्लीकेशन. इफ यू हैव एनी ऑब्जेक्शंस, you can come up. यहाँ पर आपकी टेक्निकल एग्जामिनेशन नहीं होती है, इट्स अ पार्ट ऑफ द प्रोसेस. So in this publication, जैसे I gave you example that दो फ्रेंड्स थे, एक के माइंड में आइडिया आया, उसने अपना काम शुरू कर दिया पर एप्लीकेशन फाइल नहीं की और दूसरे ने जाके फाइल कर दी और वो पब्लिश हो गई. Now the first friend, he can go and claim that this was mine. Now यहाँ पर इट्स वेरी वेरी इंपॉर्टेंट टू अंडरस्टैंड, मुझे डॉक्टर उज्जवल सर ने भी यहाँ पे क्वेश्चन पूछा था एग्जामिनेशन के लिए. अब यहाँ पर इन्वेंटर्स को मालूम नहीं होता है कि एक यहाँ पे फाइलिंग स्टेप पे यू हैव टू अप्लाई एट गवर्नमेंट ऑफिस, पेटेंट ऑफिस, एंड देन यू हैव टू फाइल अ सेपरेट एग्जामिनेशन रिक्वेस्ट फॉर द पब्लिश्ड एप्लीकेशन. जब तक आप एग्जामिनेशन के लिए रिक्वेस्ट नहीं करेंगे आपकी एप्लीकेशन आगे मूव नहीं होगी. योर एप्लीकेशन विल बी एग्जामिन्ड टेक्निकली, जैसे आपका रिसर्च पेपर टेक्निकली जो एग्जामिनेशन होता है बिफोर पब्लिकेशन, यहां पर उसकी एग्जामिनेशन आपकी आफ्टर पब्लिकेशन होती है. यू हैव टू फाइल द रिक्वेस्ट फॉर विच देयर इज अ गवर्नमेंट फी एज वेल. कई बार इन्वेंटर्स परेशान हो जाते हैं कि यहां पर भी फीस आ गई, बट यस प्लीज इसको नोट कर लीजिए. एंड दिस एग्जामिनेशन रिक्वेस्ट कैन बी रेज्ड आल्सो एट द टाइम ऑफ फाइलिंग. अगर आप फाइलिंग के टाइम पे अपनी एग्जामिनेशन करवाते हैं, दिस विल सेव योर टाइम. आपकी एप्लीकेशन जल्दी मूव होगी, जिससे आपकी एप्लीकेशन विद इन अ ईयर प्रोसेस हो जाती है इवन विद द नॉर्मल एग्जामिनेशन. एंड देन आपकी एग्जामिनेशन होगी, सो देन कंट्रोलर विल सेंड FER मींस एग्जामिनेशन रिपोर्ट भेजी जाएगी आपको, जिसमें दे विल से दैट ओके वी हैव these objections. एंड देन जैसे कि एक कोर्ट में judge says that okay these are the objections, and then lawyer on your behalf they gave their justification. Similarly here also we give our justification to overcome the objections which your patent agent prepares. And then अगर वो objections overcome हो जाते हैं, then the patent office is going to give you grant of the patent rights. And if it's not there, then they will ask for hearing. Hearing in which the patent agent he or she is going to represent you, physically through video or physically to the patent office. This is the patent certificate, granted patent certificate, how it looks like. So information to be submitted to your patent agent: self-check on novelty of your idea, name and address of all the inventors, signatures of the inventors, complete details of your invention, all will go. So each one of us is a born inventor. Our mind thinks 60,000 to 80,000 thoughts per day. Now we have to identify, we have to filter that which thought to be converted into, useful idea, which can be beneficial to the society. Now it's very much alarming that China is filing many patent applications, not in their own country, but in our country as well. Or aisa bhi na ho. And I work for like many foreign attorneys also and some inventors we have. तो often कई बार ऐसा भी होता है कि जब मैं novelty सर्च करती हूँ ना, तो I don't get any patents, but China का मुझे पेटेंट जरूर मिल जाता है. तो China is trying to protect their property, even a small property. तो ऐसा भी ना हो कि चाइना ने वो इन्वेंशंस अपनी हमारी मदरलैंड पे सिक्योर कर ली हैं. दे हैव बिकम ओनर ऑफ दोज इन्वेंशंस जो कि हमें पहले से मालूम था, और विच वाज लाइक कि हमारे माइंड में था कि हम उनका पेटेंट पढ़ के सोचे ओह ये सॉल्यूशन मैंने भी सोचा था पर मैंने तो फाइल नहीं किया. सो इट शुड नॉट बी लाइक दैट. एंड डेफिनेटली देयर वुड बी IP वॉर ऑल्सो इन कमिंग फ्यूचर. और ऐसा भी ना हो कि हम अपनी कंट्री में रहकर हम अपनी ही सोचा हुआ हमने आइडिया जिसको हमने लीगली प्रोटेक्ट नहीं किया, बट वी स्टार्टेड अवर बिजनेस, और अब उस बिजनेस को आगे बढ़ाने के लिए हमें चाइना का कोई इन्वेंटर है जो कि ऑनर बन चुका है उस टेक्नोलॉजी का हमारी ही कंट्री में, एंड वी हैव टू टेक परमिशन फ्रॉम हिम. सो दैट वुड बी रियली वेरी एम्बैरेसिंग सिचुएशन फॉर अस. These are the services which we provide for patent, trademark, design, and copyright. And these are the countries in which we provide services. Here just small, often people ask me कि ma'am company का name हम pronunciation नहीं कर पा रहे, or is it a French name? So it's not a French name, it's Indian name only. So uni means, according to our manuscripts, uni means Vishnu, unique. So Shiv, so that unique. PA means patent, TR means trademark, DE means design. So unipatred, so like for intellectual property, your idea has to be unique. So that's why, this was a reason behind this concept. And these are my details, my email address and my phone number. So you can just note it down. If you have any queries, you can just contact me. Thank you. Any queries?
Thank you so much, Ms. Neha, for this wonderful talk. And I think now most of the query of our participants have been solved. So one thing which I would like to add, or I would like to ask in this, when you have filed your patent, it got published, you got some objections, and you filed the response of that objections. So most of the things have been already covered, but after the filing of your objection, reply to the objections, so how much time it will take to get the patent?
Actually, there are so many points. Firstly, I will correct you here that after filing or before publication, there won't be objections technically. There would be objections on any formalities, any legal formalities if it's there. So then it would be there. But that is like nothing related to your patent application. Like some, you have not submitted some documents, so that only that kind of objection will come. Actual objections will come only after you put the examination request for examination. So then only objections will be raised up. Now after filing the response, now for filing the response you get 6 months time. Okay, within 6 months, as early as you give the response, your application will be proceeded further, and from that time you get 6 months time to get the grant. So 6 months is the maximum time, but like within 3 months, every like hearing, written submissions, everything is being done.
All right,
So
thank you.
6 months you can take.
Thank you so much. So one of our participants, Shivam Sharma, has asked that can we patent any exercise which he created by his own? Type of exercise.
Can we patent any exercise which I created on my own? Exercise here, physio say related exercise or like?
Yes. He is a physiotherapist, right? So he is asking about this thing.
No, see, I mentioned one of the criteria for the grant of patent rights, that is industrial applicability. So क्या आप इस exercise को are you able to manufacture it in industry? No.
Exercise is a form of like we do it on our own. And I have seen
वो exercise जो है, क्या पहले बात तो क्या वो product है या process है या आप उसको इंडस्ट्री में मैन्युफैक्चर कर सकते हो?
but next time हम कैसे कर सकते हैं?
हाँ, नहीं कर सकते ना, तो आप उसको पेटेंट फाइल नहीं कर सकते हो.
Like I have seen जैसे कुछ physical tests होते हैं, it's on the name of the person has named on.
Yes, for that you can copyright. आप अपनी exercises को या आपका जो भी ideology है, you can just copyright it.
Okay, thank you.
So I think that now most of the queries has been solved. So for the further proceedings, I would like to request Dr. Reena Saini to propose a vote of thanks. Over to you, ma'am.
Hello, can you hear me, Dr. Ujjwal?
Yes, ma'am.
Okay. First of all, hello, ma'am. Myself, Reena Saini. I am Associate Professor in Department of Biotechnology, and I am also IP Coordinator of our university. First of all, I would like to thank you, ma'am, for this very wonderful and insightful talk. And I think this is eye-opening regarding the IP war that you talk about. I really enjoyed your talk, and I hope that all of our participants also enjoyed it a lot. Also want to thank all the attendees for participating in this talk, because maximum participation give us a lot of encouragement so that we can organize such more and more such events. Then I would like to thank our HOD, Department of Biotechnology, Dr. Anil Sharma, who's always encouraging us for organizing such events and always giving us this positive environment to work on with all our colleagues and everybody in the department. Lastly, Dr. Ujjwal, I also would like to thank you for being consistent and organizing such events and giving me this opportunity to giving the vote of thanks. And ma'am, I think we'll keep in touch for future any kind of help from your side, and we'll keep bothering you and calling you and giving you for more and more such talks from for our students and for our faculty members. Thank you so much, everyone.
Thank you, Ms. Neha. Thank you, Dr. Reena, as well as Dr. Ujjwal for successfully organizing this wonderful talk. And thank you for your words as well. I had a question for Ma'am Neha.
Sure, sir.
Ma'am Neha, if you could elaborate upon, because I also have a little doubt about filing at the international level, like in the, if we file for the African patent or German patent, do we have to take some prior permission from IPO, Indian Patent Office also regarding this, or we can directly file to these countries?
Sir, if we go by law, yes, we have to take permission.
Okay.
And, for that we have to file FFL request.
Okay.
But then again, if I have not to file that particular application, if suppose you are going directly to South Africa and you have not to disclose back in India, so then you can go for that. But then again, it's not written anywhere in the patent law that, you can go, directly, and if you don't want to publish back in India, like in US Patent Act, they have explicitly mentioned that if you want to file your patent application directly in any foreign country, you can go ahead without permission.
Okay.
And if you don't want to file back in US. So far, many inventors, they have filed patent application overseas without seeking permission from Indian government. But those applications we cannot get published back in India.
Okay.
Of course, they would be objected.
Thank you. Thank you, ma'am. Thank you. It was really a very nice talk, and I think all the participants might have enjoyed the talk and try to inculcate all your all the key elements which they derive from the talk into their day-to-day duties. Yeah. Thank you. Thank you very much. Thanks a lot.
Just to mention one more point regarding this, permission. Idea behind getting this permission from Indian government is that the government wants to check if your invention is not hampering any security of India. So that's why, this is the intention behind it. So inventor has to ensure if they are filing their application directly in overseas, they have to ensure that it is not hampering security, means it is not related to defense or bombs or military or, any military related equipment. So it should not be like that.
Okay. Thank you, ma'am. Thanks a lot. Thank you so much. Okay.
Thank you so much, sir. Thank you, ma'am. And the last announcement for the participants. So please fill up the feedback link to get your participation certificate. The link has been shared in your chat box. And this is all from our side. Thank you so much, and thank you all the participants.
Thank you, ma'am.
Thank you.
Thank you so
Thank you.
much.
Thank you.